The Industrial Revolution has moved the business world away from the mentality of employees as disposable. In the modern era, businesses are expected to provide a safe work environment and protect their employees. So the question is, do you need workers' comp and disability in New York? The simple answer is yes. It is the right thing to do, and it's the law. You do need coverage for people whom you have employed. Even if they are volunteers or donated labor from your friends and family who work your business, you need workers' comp. Yes! Both full or part-time employees must be covered by insurance because if they make a claim against you in the event of an injury, the absence of legally required coverage can be detrimental for you and your business in the form of fines, thousands or even tens of thousands of dollars. New York State has no sense of humor. So, how do you determine workers' comp premium cost? The workers' comp premium is determined by how much payroll and what type of work your employees do. For roofing staff, the rate will be higher because of the higher risk of injury, but it will be less for desk clerks since their chances of getting hurt are minimal. While workers' comp and disability in New York is a law, you are not required to have a workers' comp or New York State mandated disability if you have no employees. However, you must still opt for it to cover for your injuries, especially if you work as a subcontractor, since most landlords and GC that you work for will demand the coverage, because the GC and landlord is responsible to cover you on their policy. New York State makes it a must to have legally bound disability insurance for your employees. It can cover for loss of employees' wages for a set period when they are injured, ill, or pregnant outside of work and cannot go to work. If you get pregnant at work, that is something completely different. This insurance rate will be a little higher for females than males and covers a base loss of income in New York State starting at $147 per week with higher income option available. While both workers' comp and disability insurance policies are required by a business to cover any potential loss of wage due to illness or injury, workers' comp only covers medical bills and loss of wages for injuries that happen on the job, while disability can cover employees for loss of income for sickness or injury, which doesn't occur on the job. However, there are some exceptions to these rules. Intentional injuries, which are caused to get out of work and claim insurance income, simply are not included. PTSD situations and emotional trauma are also not covered under these insurances, while injuries during a flight are also not covered. But disability will cover loss of wages if you are out of work. If an employee gets injured while they're intoxicated, they cannot get any benefit either. So, what happens if your company doesn't have a workers' comp or disability insurance? And it's not only your workers who need workers' comp and disability compensation, you too are not immune to injuries and illness, which means you should also include yourself, even if you are a lone worker. New York State workers' compensation law states how many weeks of benefits an injured worker with work-related injuries will receive for a scheduled loss of use award based on the percentage of the injured body part as shown in the following chart. A simpler formula to evaluate the same is average weekly wage divided by 2/3 multiplied by the max number of weeks allowed multiplied by the percentage of loss of use. And before you even think about skipping them, so get compliant and opt for a workers' comp and disability insurance for not just your employees, but also yourself. For questions or a quote, contact us at joyceins.com.